He's present, Your Honor.
Mr. Blackman, sir, my name is Brad Gardner. I'm a judge here in Magistrate Court. It looks like you appeared before me on October 6th for first appearance. Your lawyer has asked for us to consider a bond motion first, so that's what we will do. I want to caution you that anything you say here is not private or privileged, so don't say anything that you would not want the whole world to know. Okay, sir?
Correct.
All right, Mr. Moore.
Thank you, Your Honor. And Your Honor, I want to start by saying I appreciate the court's willingness to at least hear us on the issue. The primary reason why I wanted to address bond upfront and in lieu of a preliminary hearing is just because of the nature of the charge, being that it's a suspended license offense with tag light tickets to go as well.
Right.
As of today, I believe it's been approximately 40 days that he's been in custody on this charge. Mr. Blackman is a local resident. He's got a local address. He is gainfully employed. He's got a mobile barber business that he's been operating for 20 years. He's married. He has 4 children, ages 7, 8, 13, and 14, 2 boys and 2 girls. Of course, defense acknowledges and admits that he does have some criminal offenses in his past, and that, you know, obviously I assume that the state intended to bring that up. However, just the simple nature of the charge that we're currently dealing with in the amount of time that he's been in there, I have to ask the court if you would consider an unsecured judicial release, given all of those considerations, you know, especially his stability and the nature of the charge. And so for that reason, Your Honor, we would request the court to allow us to have him released on unsecured judicial release. And obviously we would be waiving his preliminary hearing at that point and allowing him to get back to his family and come back to court in a few months to deal with his suspended license charge, which in all honesty, you know, the amount of time that the state will be seeking is very, very likely much less than 40 days that he's currently spent in custody. Thank you, Your Honor.
Mr. Steele?
Yes, Your Honor. Quickly on a driver's history, there was a operating vehicle with suspended violation in 2015 out of Fulton County. There's been license suspensions based on child support obligations, failure to appear out of Fulton. But most of these 2019, 2021. Did you want me to go through the criminal history as well, Your Honor?
No, I can see the criminal history.
Okay. Your Honor, we will leave this in the discretion of the court. The state holds no position. We'll leave it in your discretion, Your Honor.
Let me ask you this, Mr. Steele. Is your office still going through the amnesty program as it relates to prior tickets and things that are open?
I know our office especially deals with like equipment, essential. That's what I sent over to Mr. Moore as well. If they're fixed, we're willing to dismiss those. You know, we don't want to hold people up for equipment violations, Your Honor.
Okay, because this is not the crime of the century.
No, it's not. Sure.
And it's probably costing the county more money to house Mr. Blackman than to just address the issues. Before I get to the unsecured judicial release, is there like a, I don't know, a way to have like a, in my opinion, be like a conditional discharge? Like there's 6 months that he's given to kind of bring these issues up and resolve these matters. And if he can show at the end of 6 months that these matters have been resolved, that charges will be dismissed because I agree with Mr. Moore. I mean, since I've been doing first appearance, I've had people that they've gotten out on bond and they pled their case out and then got rearrested before the date that their preliminary hearing was supposed to be held. So, it may not be within your discretion, but I'm just thinking sort of big picture.
Well, Your Honor, the offer that I essentially extended to Mr. Moore was for the license credit for time served. Like you just said, he spent 40 days in jail. And the 2 tag lights or tail lights were fixed to dismiss them, Your Honor. And I think that's kind of pretty fair based upon the issue at hand.
And when you said for the license, what do you mean?
For the license charge.
The suspended license. I just didn't understand what for the license.
Yeah, suspended license charge, Your Honor. I was offering credit for time served.
And we did discuss that plea offer, and myself and my client both felt that we still wanted to address bond conditions and have him appear on an out to bond calendar to address that if possible. And the primary reason for that, we would love to handle his business right here and now, today, if at all possible. But of course, we can't do that. I mean, essentially just the posture of the case, magistrate court, we can't resolve a state court misdemeanor matter, with a plea and have him sentenced down here. My primary fear is, his case gets bound over, and then he's sitting another 15 days waiting to go to state court to then accept the state's credit for time served offer, which is not unreasonable. It's just the process of getting there is so problematic and frightening, especially for, people who've been in jail for 40 days, that it made us want to look at that as a secondary option.
All right. You're losing me on the logic a little bit, Mr. Moore.
So, Your Honor, I guess the idea being, fast track offer is conveyed, and let's just say, yes, Your Honor, we accept the fast track offer. Go ahead and bind the case over. In no offense to Mr. Steele or the court or anything like that, just in past experience, the timeline from today until my client finds himself on a jail arraignment in a position to be sentenced on that agreement could be anywhere from 5 days to 30.
Okay, so I understand what you're saying, and let me rephrase it. You're essentially saying, hey, not saying that offer is a bad offer, but the time from acceptance to the offer being carried out, he's going to be sitting in jail.
Right, John.
Okay. I mean, it sounds reasonable to me, Mr. Steele. All right.
Oh, go ahead.
I'm sorry. Go ahead.
No, Your Honor. I was just saying I wasn't raising any objections to that, Your Honor.
Okay. All right. Well, Mr. Moore, I'll grant the unsecured judicial release if you draw up the paperwork and send it to both myself and Mr. Steele.
Yes, Your Honor. I'll do that as soon as I get an opportunity here this morning.
Okay. All right. So, Mr. Blackman, what that means is that there's going to be an order issued for unsecured judicial release, and you'll just have to work with your lawyer, Mr. Moore, as it relates to the resolution of your case.
And Your Honor, I'll file the waiver simultaneously with that and email that to you, Mr. Steele.
Okay. All right. What's the next case?
Stewart,
Done. Anybody else, sir?
All the way up to the one that faces the wall.
Anybody else?
Yes.
Heather Rhiann Stewart.
Hi.
Speak up when you.
Hi.
Yes.
How are you? Ms. Stewart, ma'am, my name is Brad Gardner. This is going to be your preliminary hearing today on these charges. I just want to caution you that anything you say here is not privileged or private. So don't say anything that you would not want the whole world to know. Okay, ma'am?
Hi.
And okay, Mr. Steele, how many witnesses you have in this case?
just one, the officer, Your Honor.
Okay, you can bring them up and swear them in.
Officer Covington, you can turn on your mic and camera. May you please raise your right hand.
That's you.
And do you swear to tell the whole truth?
I do.
And can you please state your full name for the record?
Leon Covington,
And Officer Covington, where are you employed?
Clayton County Police Department.
And how long have you been employed there?
3 years, but I feel like 15.
And were you employed there on September 27th, 2021?
That's correct.
And were you called out to 4489 Northwind Drive, Ellenwood, Georgia?
That is correct.
Is that location in Clayton County, Georgia?
Yes, sir.
Is it a residential or commercial property?
It's a residential.
And what kind of property is it? Is it like apartment complex, a home?
It's a home, but it houses young juveniles with mental incapabilities. So it's a group home.
Okay. And why were you called up to that location?
I was called out there for a disturbance between the said accused. Hello?
I think
We can
someone's
hear you,
logging
sir.
on. No, someone's logging
Okay.
on. Yeah.
Okay. Yeah, I was dispatched to the location in reference to a disturbance between the defendant and some workers that work at the location and another girl that also resides at the location.
So speaking of, you just said you spoke to kind of a few people. Who's the first person you made contact with?
I spoke with a Miss Gowanda. She's a coordinator at the location.
And what did she tell you happened?
She alleged that the defendant made entry into an office area at the location, and she was told by other workers at the location to leave the area, and she refused to leave. And the defendant and a Miss Kiana had some words exchanged, and the defendant told her to get out of her face, and that's when Miss Gowanda intervened, and she was kicked in her stomach. And after she was kicked in her stomach, another resident at the location made contact with the defendant, and they exchanged words and got into a physical altercation, which led to the defendant biting the resident, also the victim, in the left tricep area. And
Okay.
then the defendant left after.
One second, officer, 1 second. I'm gonna stop you and kind of back up, because that was a lot of information at one time. So I want to break it down a little bit. So the defendant was in an authorized only area.
Say that one more time, sir.
The defendant was in an authorized only area. So like
Correct.
employees only, workers only.
Yes, that was a workspace only.
Okay. And who told the defendant to leave?
Miss Kiana and another employee that I didn't get a chance to speak with.
Okay. And so when she was asked to leave, did the defendant leave that area?
No.
And so I heard you just said about some attack. Who did this physical contact occur between?
The physical contact started with the defendant and Miss Gawanda.
Okay,
and
so
then
and Ms. Gawanda is one of the workers.
yes, sir.
And who made contact first?
Made contact with the defendant first.
No. So for the physical contact itself, you just stated Ms. Gawanda got kicked in the stomach. So was this essentially physical contact originated with the defendant or Ms. Gawanda?
Yes, that's correct. Because it stemmed off of the defendant getting upset about being told to get out of the office space, and when Ms. Gawanda intervened with this with the altercation, that's when she was kicked in the stomach by the defendant, and then the defendant lost her temper and threw the desk that was inside the office area into the drywall, causing damage to the drywall.
And during this time, was there any physical contact between her and I think you said Ms. Kiana?
No.
And did the defendant make physical contact with another juvenile at this location?
That is correct.
And can you describe that contact?
Well, according to the victim, juvenile, she advised that the defendant pushed her, which caused her to punch her in the face. And then they immediately got to tussling and fell to the ground. And that's when the defendant bit the victim on her left tricep, I believe.
And did someone on the scene contact the police?
Yes, Miss Kiana.
So does the defendant currently or formerly live at this group home?
Yeah, she lived there at the time of the incident, yes.
Did the other juvenile currently live at the group home at the time of the incident?
That's correct.
Did Ms. Gawanda reside at the group home at the time of the incident?
No, sir.
Did Ms. Kiana reside at the group home?
No, sir.
And speaking of the bite on the other juvenile, did you observe any bite marks on the juvenile?
Yes, I observed it and captured pictures of it.
And at any point, did you make contact with the defendant?
Yes. After she left the location, myself and another officer went out to check the area to make contact with her, and that's when we found her walking back towards the incident location.
And is she on the Zoom call right now?
Yes.
Can you describe what she is wearing?
From when I seen it, it appeared that it was a green jumpsuit, a white female with blonde hair.
Your Honor, let the record reflect the defendant has been identified.
I will I'll let that go, but Mr. Steele, from a suggestive standpoint, there's only one person on every case that's going to be in a jumpsuit at the jail where it says Clayton County Jail. So I'll let you say that, but it really doesn't carry a whole lot of weight.
And when you made contact with the defendant, did the defendant say anything of interest to you?
Can you be a little bit more specific?
Did the defendant state to you if anything happened, if there was any physical contact with anyone?
Yes, she did advise that 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 she did advise that her and the juvenile victim got into a physical altercation, which stemmed off of the victim pushing her first, which caused the whole fight between them. I can't recall if the defendant explained to me about the incident that occurred in the office, the initial incident that occurred in the office area. It seemed like she was more concerned about the fight between her and the juvenile victim.
No further questions, Your Honor. Thank you, officer.
Ms. Gross?
Officer, a couple of things just in clarification. When there are two females in a fight, there's a whole lot of she's that are said, and I just want to make sure I understand who did what. When you
Okay.
originally spoke with Ms. Gowanda, she told you that our client came into the office area, was told to leave, and she refused. And then there was an argument that ensued, a verbal argument that ensued about that. Is that the point at which you were told the other juvenile came into the room?
Yes, during that verbal altercation, the juvenile victim heard the altercation going on, and then that's when she made contact into the office area to see what was going on.
Okay, so you had two adults who are employees of this group home who were having, even if we call it an argument, who were having an argument with our client, and then a juvenile came into the room and inserted herself into this argument. Is that what you were told? And
Yes, ma'am.
at that point, that juvenile pushed our client. Was that everyone's consistent story?
So it was actually a conflicting story because the juvenile victim with the bite mark on her arm, she alleged that the defendant pushed her first, which caused her to punch the defendant in the face. And the defendant alleged that the juvenile victim with the bite mark on her arm pushed her first, which caused the fight between them.
Okay. And did you speak with either Miss Kiana or Miss Gowanda about who pushed first?
I don't believe so. I think they just observed the fight and tried to separate themselves and contact the police.
Okay. Okay. Now, you said this is a group home for, I believe the way you put it was juveniles with mental difficulties.
Yes.
And capabilities, I think is the word that you used. Did you have any conversations with the adults at that location about our client's mental health status?
Yes. I spoke with Miss Gowanda, who advised that, was it Miss Gowanda or Kiana? I believe it was Miss Kiana who advised that the defendant had been diagnosed with schizophrenia, bipolar, and depression. Yeah, it was Miss Kiana.
And was there any conversation with any of those group home workers about whether or not our client was in need of perhaps medical assistance or hospitalization at that time?
I don't believe. Well, I can't remember. That'd be the better way to say I don't remember.
Okay. Was there any conversation with them about whether or not she was current on her medications?
I don't recall.
And when you first arrived on scene, you said our client was not present. Is that correct?
Yes.
And you located her outside walking in that area. Is that correct?
Yeah, she was walking in the middle of the roadway back towards the incident location.
Okay. And at that time, you had a conversation with her about what had happened?
Yes, ma'am.
Was she compliant with you at that time?
She seemed a little distraught, but she was answering my questions. correctly. She, you know, I asked her what had happened, and she explained that the staff was getting on her nerves and making her mad. And then that's when the whole altercation began.
Do you know who has custody of our client?
To my knowledge, the group home has custody over the client.
You don't know if she's currently still in DFACS care?
No, I'm not sure. I don't.
All right, Your Honor, I believe that's all I have this time.
Mr. Steele, any redirect?
No, Your Honor.
Okay. May this officer be excused?
Yes, Your Honor.
Mr. Covington, you can be excused, sir. Thank you.
I appreciate it, sir. Have a good day.
You too. Mr. Steele. You're going to reserve?
Yes, Your Honor.
Ms. Gross?
Your Honor, I believe this is not necessarily a typical situation, but I think it's a situation that we see frequently where we have, in this case, a very, very young lady who is been placed in a group home and has some significant mental health issues, who, according to what the police officer said, is having somewhat of a difficult conversation or an argument with some of the staff at the group home when another juvenile comes into the room and inserts herself into that argument. And then, of course, there's some question as to who pushed who first, but, you know, according to our client, the other young lady pushed her first, which caused the physical altercation that occurred between the two young ladies. I'm somewhat concerned that there was no one inquired into her mental health status, to whether or not she was on her medications, to whether or not she needed to be taken to a hospital. Was she in the middle of a mental health crisis? And apparently there was not any attempt made to contact DFACS or anyone else who probably at that point had custody of her. So, Your Honor, it appears to be this was a mental health situation as opposed to a criminal situation that needed to be dealt with in a different manner. Had perhaps they taken her to a hospital instead of to the jail, the outcome would have been different. So we would just ask that you take into account the testimony about the fact that another juvenile came and inserted herself into this situation when adults clearly had it under control. And at that point, there was no physical confrontation going on until that juvenile came and inserted herself into the situation. And based on that, we would ask that you not bind the case over, or that in the alternative, because our client has been in custody for such a long period of time, we would ask, this occurred on September 27th, we would ask that you release her on an unsecured judicial release to her, to DFACS, who has custody of her, and with conditions that she take her medications and that she seek any kind of mental health treatment that is necessary.
Mr. Steele?
Your Honor, while I hear the defense, and it's always great to see them zealously advocate for their clients, mental health issues is very important, but it does not excuse violence. It does not allow violence, Your Honor. I kind of heard in that argument that this juvenile antagonized this attack when essentially there was already an attack happening. Property was already damaged and destroyed, a desk thrown at a wall, a worker being kicked in the stomach. There is also, and I'm not here to put on a defense for the juvenile, but defense of another is something that we're kind of seeing here in this situation. The battery had already taken place. The criminal trespass damage had already taken place. And for that, Your Honor, we are asking for you to bound this case over.
Okay. These are my concerns. This is a group home. And I'm I'm concerned that it doesn't appear from the testimony that I've heard that there is anything done other than to call the police, to have the police to come and to arrest Ms. Stewart. There was a question in my mind that it didn't come out as to why they didn't go through the process of taking her to a mental health hospital, which is commonly referred to as 1013. If she's in a group home, she has mental health issues, and this is going on, why is the first step to take her to jail rather than to get her the care that she needed? Ms. Gross, do you have any idea what is going to happen to Ms. Stewart?
Your Honor, I just got the name and the phone number for her defects caseworker this morning. I had tried to meet with Ms. Stewart yesterday and we weren't able to we connected in the last 30 seconds of her jail visit. So I've not had a chance to speak with her defects worker. I would, in my experience, what will happen is defects will have to fund her a new placement. And that would be up to defects to choose a place for her to go, but they could take custody of her immediately. They do have the ability to put her into a hotel with a caseworker until they're able to find a placement.
So this is what my concern is, Mr. Steele, as it relates to this case, and maybe you can help me with this. I understand that the allegations that are there, and this is not, of course, a trial, and I'm not here to make trial level decisions. Again, this is one of these situations where maybe the only thing that is available is to take the person to jail. But it just seems that there is enough information that is present that jail is not the immediate thing that has to happen. I'm also aware and cognizant that Ms. Gross, for people like Ms. Stewart, being mentally ill doesn't become a get out of jail free card, and that you can do whatever you want to do and then claim that I was off my meds or mental illness, and then it just goes away. There was a fast track offer that was extended.
Yes, Your Honor.
And my understanding is that Ms. Stewart has rejected that.
That's correct, Your Honor.
Okay, well, I'm gonna bind it over. This is, in my opinion, a meet in the middle case, but if no one wants to meet in the middle, then you gotta let the process play itself out.
Thank you, Your Honor.
Your Honor.
Yes, sir. Okay, what's the next case?
We do Simmons, Your Honor.
John Leslie Simmons.
Simmons,
Yes, Your Honor.
Simmons,
Mr. Simmons, my name is Brad Gardner. I'm Magistrate Court Judge. It's your preliminary hearing. I just want to caution you that this proceeding is not private or privileged. Anything you say during this proceeding will be broadcast to the public. So please don't say anything you wouldn't want the whole world to know. Okay, sir? Okay. You have just one officer?
Yes, Your Honor.
Okay. Would you call your witness, please?
Officer Sharp, may you please raise your right hand? Do you swear to tell the whole truth?
I do.
And can you please state your full name for the record?
Officer Dwayne Sharp,
And Officer Sharp, where are you employed?
Clayton County Police Department,
And how long have you been employed there?
7 years.
And were you employed there on October 3rd, 2021?
I was.
And on that particular day, were you called out to 7155 Babbling Brook Drive, Jonesboro, Georgia?
I was.
Is that location in Clayton County, Georgia?
It is.
And is it a residential or commercial property?
It's a residential area.
And why were you called out to that location?
In reference to a domestic call involving Mr. Simmons and his father.
And did you make contact with anyone when you arrived on the scene?
I made contact with Mr. Simmons and his father.
And his father is Willie Simmons.
Yes.
And what did Willie Simmons say happened?
Willie stated that him and his son got into an argument over some money that his son said that he owed him. During the argument, John got upset and slammed the door, damaging the door in its frame.
And was another officer on scene with you?
Yes.
Did either one of you observe damage to the door?
Yes. Officer Tharp went into the room, into the hallway, which was where the door was, and observed the damage, and I did also.
And at any point, did you make contact with the defendant?
I did.
And what did the defendant say happened?
He stated that him and his father did get into an argument, that he closed the door and that he did not damage the door. He stated that the damage was from a previous incident.
And was the defendant arrested?
Yes.
And did you advise the defendant that he would be placed under arrest?
Yes.
And what was the defendant's response or behavior after being told he would be going to jail?
He then put up a struggle, pushing Officer Tharp, who was the additional officer on scene. Ultimately, I ended up tasing Mr. Simmons, and he was placed under arrest.
So I kind of want to break that down just a little bit. So did you give the defendant any instructions when you were trying to place him under arrest?
Yes. I told him this. He was sitting in a chair at the moment when I told him he was going to go to jail. I told him to stand up. He stood up. I told him to give me his hands, at which time we tried to place handcuffs on him. He ultimately ended up pushing Officer Tharp and trying to run away from the location, and he was subsequently tased.
And did Officer Tharp sustain any injuries?
No visible injuries. She did have complaints of her arm hurting, but that was it.
And excuse me. So was the defendant eventually apprehended?
Yes.
And when he was apprehended, did the defendant still try to resist at any point?
While he was on the ground, he did continue to resist. He tensed his muscles up while on the ground, causing me to have to tase him again as I continued, and myself and Officer Tharp continued to tell him, give us his hands, give us his hands. But eventually he gave us both hands and he was placed under arrest.
I'm sorry, Mr. Steele, let me interrupt for a second. I'm looking at the warrant or the WAA, and I did the first appearance, and the obstruction of law enforcement officer was written up as a felony. And I said I bound it over to, not bound it over, but I set preliminary hearing dates for felony. Is there a reason that this is in misdemeanor?
I am not sure, Your Honor, because
Yes, felony obstruction should have been.
oh, okay. Excuse me, I did not know, Your Honor. I had
No,
it
I
on.
mean, it's not your fault. But I was looking at it, and then when I'm hearing the testimony, it sounds like the obstruction is offering force or violence to a law enforcement officer, which is a felony.
I mean, I agree with you, Your Honor, but I did not know it was written up to be bound over to felony.
Your Honor, this client's been in custody for about 45 days. It's possible that the district attorney's office looked at it and declined prosecution. Is there any way for Mr. Steele to check on that for us?
And that's why I interrupted, because I didn't know if there's something that had taken place.
If you give me like a quick second, I can try
Sure.
to pull up. But that's all the question I had for the officer, Your Honor.
Okay, but Officer Sharp, I'll tell you this: I've been doing first appearance for most of the year, and when I'm looking at this, it brings back nightmares because it's almost illegible when I'm trying to read it, and I have dismissed cases where I couldn't read what the officer wrote. So,
Yes, Your Honor.
I mean, I can't make a determination if I can't understand what's being written.
Yes, Your Honor.
I'm not seeing anything on my side.
Okay. Let's see. So I'm looking at it. I set felony first appearance dates. I set it for next Monday as being on the first appearance calendar. I'm sorry, preliminary hearing calendar for felonies. Ms. Gross, you can go ahead and ask the questions that you need to ask of this officer while we try to figure out what happened.
Sorry, Judge, I was just trying to look as well to see if I could figure out the fact that we were appointed Just trying to figure out when we were appointed and if I can get any information from that. Okay, so the only questions I have of the officer are concerning the damage to the door. Officer, our client told you that that door had been previously damaged in a previous incident. Did you have any conversations with his father about whether or not that door had been previously damaged?
Yes, he stated that the door was previously damaged, but he had repaired all the doors since that incident occurred.
Did he describe to you the previous damage to the door?
He just stated that the doors were damaged. He wasn't specific.
But he claimed he had fixed the door since the last damage?
Yes,
And you said you saw the door as well, is that correct?
correct.
Is there any way for you to tell how recent the damage to the door was?
No.
Okay, that's all I have, Your Honor.
Okay. Let's see. Give me 1 second. I'm looking. On the CAA form, I did not put an F designating it as a felony. I cannot remember when Ms. Kimbrough made that request. And I'm looking at my records because I hold on to my records. Let's see. So it looks like I didn't make the designation either on the calendar or on the CAA form of the felony, but oh, wow. Yeah, this must have been a crazy day. Because I have 2 separate dates written. I have a misdemeanor date on the calendar and the felony date on the CAA form. Wait a minute. Hold on. So this is entirely my error. I placed misdemeanor dates on the CAA form and on the calendar. On the WAA, I placed a felony date for the prelim. So this is my error. So as I've heard and received the testimony, my thought was to bind over the simple battery on the police officer, and not bind over the obstruction and the criminal trespass. But today is not the day to deal with the felony. Today is the day to deal with the misdemeanor. So let me hear your thoughts, Miss Gross and Mr. Steele.
Your Honor, I mean, obviously my thought would be, I believe that the court can bind everything over as a misdemeanor. I believe that this would actually just be a simple battery on a police officer, and that he was simply struggling, physically struggling, trying to get away. And in doing so, pushed the officer. She didn't have any visible injuries to her. And so we would ask that you just bind everything over as a misdemeanor. I'm not sure what kind of complications or difficulties will come if these cases get separated and bound over to two different courts. That does seem like it might be a significant problem.
Yeah, I don't think separating them would be in the best interest, because it could almost be, especially is rooting from the same incident,
Right.
kind of double jeopardy for the defendant. Your Honor, you could still bind it over, and it just will be handled as a high and aggravated misdemeanor for a simple battery against a police officer.
What's your response to that, Ms. Gross?
I think that would be appropriate, Your Honor. I believe it could be handled as that all the charges could be handled as misdemeanors, and I believe that's appropriate given the facts of the case.
Okay. Well, that's what I'll do. I'm going to bind it over as misdemeanors. And we'll see what happens with the, as I always tell everybody, I'm just a lowly magistrate court judge. Mr. Steele can undo anything I do this afternoon. So thank you for your testimony, Officer Sharp. You are free to go, sir.
Thank you, Your Honor.
Okay.
Thank you, Officer.
Okay, what's the next case?
Okay, Your Honor. I have two announcements, and of course, I would leave it in your discretion to grant or not. The case of Washington and the case of, I'm going to really jack this name up, Mija Numez.
Oh,
Hello, Your Honor.
yeah.
Judge, are you finished with Mr. Simmons?
Yes, sir. Mr. Simmons can go back.
Okay. He was asking about the decision. So
The case is going to be bound over as misdemeanors.
okay, sir.
Okay. And I'm sorry, Mr. Steele, tell me the first name again.
For
Washington?
Washington, yes.
Okay.
We have been trying to get in touch with the officer. We had confirmation it would be here, but we have not heard. So we're asking for a continuance. I'm not sure if it's been on before, Your Honor.
Okay. Let's see, who's representing Mr. Washington?
I am, Your Honor. It's actually Miss Washington.
Miss Washington, sorry.
That's okay. And we were just appointed this week, so I don't know if the case has been on the calendar before.
Let's see. It looks like from first appearance. Wow. It was written as a felony.
Your Honor, because the facts of the case, she sprayed the defendant with a pneumonia substance.
Oh, yeah.
And so I did reach out to the DA's office, letting them know that it was on our calendar for prelims and that we were trying to move forward, but to be in contact with them, because to me it seems like an aggravated assault, Your Honor.
I think when I saw it, I thought the same thing. But do you know if they're going to pick the case up?
Yes, Your Honor. They did state to me that they were willing to take the case. And as I spoke to my direct boss this morning, the policy from my understanding was that we still handle the prelim
Okay.
before we send it over to the DA's office.
So, Ms. Gross, did I hear you to say that you're not objecting to the case getting continued?
Yeah, that's kind of a difficult question for us, because she has been in custody. If you'll give me just a second, let me tell you how long. She's been in custody since September the 30th. So she's been in custody roughly 45 days.
Right.
You know, I believe that certainly based on my client's version of the events, it's not a felony. It would be proper to be, you know, handled as a misdemeanor. But I can't tell the court exactly what it is that happened in the last 45 days that led it to be placed on this preliminary hearing calendar. I don't know if at some point the district attorney's office declined prosecution and then changed their mind. I just don't know. I don't know what's happened in the last 45 days. I mean, I would object to it being continued simply because the client has been in custody for so long, and would ask the court that if the case is going to be continued, that the court consider an unsecured judicial release so that the client won't continue to sit for a longer period of time.
Yeah, I recall doing the first appearance on this case. And I set, like I would normally set a bond at 5,000 as a general starting point on a battery case, and either go lower or higher based upon what I see as the allegations. But it really concerned me, the allegation of throwing cleaning solution into someone's eyes, which is the allegation, of course. That's why I set a $10,000 bond, and it was written as a felony. So I would not be inclined to do an unsecured judicial release. I saw her criminal history was not significant, but I was concerned with the actions, the allegation of the actions.
Right, which of course her side of the story is different from the victim's side.
Right. So what's the issue with the officer, Mr. Steele?
We were just trying to get in touch to have them here. Like I said, first we had confirmation, and then, but I do know, essentially, yeah, they're just not responding to be here today, Your Honor.
Okay. Well, I'm gonna hold off on making a decision on that now.
Okay.
Keep efforting that officer to get that officer here.
Okay.
And then it was Mejia Nunez.
Yes.
What's your announcement on that?
The same, Your Honor. The officer thought that they were only required for tomorrow, because essentially it looks like it's one report, but it's 2 different instances and 2 different days. So they were under the understanding that they only need to be in court tomorrow for the felony. But our case was, I think, about 3 days after the felony took place.
Okay. Okay, I was looking at the calendar. It looks like the warrants were obtained at the same time.
Which is why I think the report was done at the same time.
I might be able to clear that up a little bit, Your Honor. So basically, police were dispatched. They told the police about a previous incident 3 days earlier, and the report was written on everything at one time, and the warrants were all taken at one time, but there are 2 separate and distinct incidences. And Ms. Mejia Nunez has been in jail for a little over 60 days.
Yeah, I think I remember this person also. Yeah, I do remember this person. I think the victim was his brother or something like that.
That's correct.
Yes, Your Honor.
Okay, well. So the officer saying that the officer can't be here?
Yeah, we haven't been able to get the officer to come on at the moment, Your Honor.
Okay. Oh, I must have been having a bad week that week. I dismissed the aggravated assault with a deadly weapon, but I still put it on for felony dates, and it's supposed to be today.
Your Honor, if I may, there were no felony charges attached to this particular set of charges. It's criminal trespass, but there were no felonies attached to that. The felonies were attached to the other set of charges that had happened 3 days prior.
And I think that's the one. Let's see, look at the dates, 9/6. Yeah, so I dismissed the 9/6, which is the felony, and the 9/9. Jesus, 9/6, 9/8, 9/9 looks like are the 3 dates. And you don't believe the officer is going to be able to make it, Mr. Steele?
No, Your Honor.
Let me take a look at this. Mr. Mia has 17 cycles. So, Mr. Mejia should not just sit in jail because of an error that I made, that I obviously made. What I'm willing to do, Ms. Gross, is looks like he has a total bond of 6,000.
That's correct, Your Honor.
I'll reduce his bond down to 1,500, $1,500
Is that 1,500 on?
total. So
Okay.
it's going to be 750 each, with a stay away provision.
Okay.
And I'm going to continue his case. Stay away provision is going to be to stay away from Luis Mejia Corrales and Danette Johnson.
Okay.
And I'm going to continue the case, and we'll provide the new dates. It'll be sometime in December. So if he's unable to post bond, we'll provide notice to your officers, Mr. Steele, and they'll be able to appear. If he posts bonds, it binds over by operation law.
Your Honor, just as a clarification, when I pull him up in the inmate search, it's still showing the aggravated assault with a deadly weapon. There's no bond set on it, but it is still showing him in custody on that charge. So even if he were to make bond on these 2 criminal trespasses, he's not going to be able to get out due to that aggravated assault.
Let me give you this 2000. Let me give you this number: 2021 CW 54387.
54387.
Yes, and I'm sorry, I said it was dismissed, but I did no bond. I did no bond. I didn't dismiss it. I'm sorry.
Is that the one that's on the calendar for tomorrow? Because I know Mr.
It-
Steele said there was an officer subpoenaed for tomorrow.
It has to be. So let's scrap that. We'll deal with all of this tomorrow, or I'll deal with it tomorrow. Because I was in my mind, I'd looked at it and I said, oh, I dismissed that. But then when I read the warrant, this is, if I recall the conversation, your client remarked as to why I denied bond on the aggravated assault with a deadly weapon. And I told him it's because the allegation is that you discharged a firearm and shot someone in the leg. And I think his response was something like, that was his brother, or his brother shouldn't be ratting on him, or something. He said something to that effect. So let's just scrap what I just said. He should be on the calendar for tomorrow, and I'll just deal with it tomorrow.
So just for clarification, Your Honor, are we continuing these misdemeanor charges, or is everything going to be handled together?
Everything will be handled together tomorrow. I'll be the person there. So I don't know, but it's apparently I did something I can tell you exactly. Let me go back. Because I was asked, because it was getting confusing, to make a notation as to whether something is a felony or not. And because I was basically doing everything, I knew the felony dates and the misdemeanor dates. So I knew if it was on a certain date, it's a felony. If it's on another date, it's misdemeanor. But that wasn't generalized knowledge. And so at one point, I was asked to go back and to start doing that. And let's see, this was September 30th. So I can tell you. No, I put felony on there. I put felony on the CAA appointment form, and put preliminary hearing date for 11/17 and Superior Court bond hearing date for 11/19.
Your Honor, is that on the incident from the 6th?
It's on, when I'm looking at the CAA form, it has the 3 warrants, 54387, 54388, 54389. And they're all on the same form. And I have the felony preliminary hearing date. And 11/19 bond hearing date. So it somehow it just got, I guess, crossed over on our end and got sent to you when it should have been sent to the DA's office.
So are all of the charges being treated together as opposed to being split into the 2 incident dates? Because I believe the incident on the 9th only has misdemeanor charges.
Which is the way, let me go back and look at the warrants. But the way that I read it was that this was a series of events that, although they were separate days, it was the same individuals. So it's like, it seemed like it was just an ongoing dispute. So I guess you can try to break it up and say, you got mad at me yesterday and I shot you, and the next day I punched you, and then the next day I punched somebody else, but it was all over the same argument. That's, as they would say, that's above my pay grade. That's for people with Mr. Steele's badge and distinction to make those decisions.
Okay, so just for clarification, all of these charges are going to be handled tomorrow on the felony calendar, and so those will be handled by the public defender's office, or do you need us to appear on that calendar to handle the misdemeanor charges? I just want to make sure we're doing the right thing.
And so before I speak out of school, all right, so on 9/6, the alleged victims were Luis Mejia Corrales and Danette Johnson, where the allegation is Mr. Mejia Nunez shot Mr. Corrales or discharged a firearm and grazed him in the knee area. On 9/9, he's alleged to have damaged the property of Danette Johnson by using a blunt object to cause 3 dents into her door, or his door, but I'm assuming it's her door. On 9/8, the allegation is that Mr. Mejia Nunez intentionally damaged the property of Linda Levy when he threw 2 bricks through the window, causing the glass door to shatter over the floor of the victim's backroom area. So Miss Lynn Levy is the only separate victim. But Miss Danette Johnson is the witness. So it would appear as though this was Miss Levy's house, but it's related to the ongoing dispute with Danette Johnson. So that's the way that I'm reading it. I'll listen to both sides as to what you think is appropriate.
Your Honor, obviously, it's up to your discretion. I think it would be appropriate and possible for the misdemeanor charge of the damage to the door to be separated and heard separately. We're willing to represent him on that, and we're ready to go forward, whenever the court's ready on that, if that's what the court chooses to do. I just want to make sure I'm clear on what's being required of us. We don't want to not be present at a hearing that we need to be at.
No, I understand. I understand the way that I am viewing this. Let's see. The incident locations are the same. It says 209 and 211 Monterey Circle or Monterey Circle. Monterey Circle. So these incident locations are the same. So this is just an ongoing Jerry Springer episode. So I'm going to deal with it all tomorrow.
Okay. And you do not require our presence at that hearing, is that correct?
No, ma'am.
Okay.
No, ma'am. Okay, what's the next case?
And one more request, Your Honor, for Hornsby. We could not get the officer. We had confirmation, same thing before, and have not had the officer to show up this afternoon. Well, yeah, afternoon now.
I'm sorry, which case was that, Mr. Steele?
Hornsby,
Hornsby.
I think that Mr. Moore's case.
Yes.
Okay. Battery, reckless conduct.
Your Honor, I have a quick question. Is there any other males that need to go back?
Let's see. Davis, King, Haywood, Stewart, and De Jesus can go back. Mejia Nunez can go back.
So Haywood, Nunez.
Okay, you said you asked me about who?
Yes.
Yeah, she came in the hospital.
Davis, and correct me if I speak out of school. Davis, King, Haywood, Stewart, De Jesus. But Stewart's female. Mejia Nunez and Mr. Hornsby may be able to go back. And so let me make just one statement. I am accustomed to going through and moving through things, but if anybody needs to take a break, this is the lunch hour or lunchtime. I don't want to hold anybody hostage. So let me know if you want to take a break and come back, or if we can just keep going forward.
Well, for my part, Your Honor, I'm ready to power through.
Yeah, we can go for it, Your Honor. And it
Okay.
seems like Officer for Washington just showed, Your Honor.
Okay. All right, well, that makes things easier. So with Hornsby, what's your position, Mr. Moore?
Your Honor, my position would be for Mr. Hornsby, if the state's unable to proceed, we would just ask that the warrants be dismissed.
Mr. Steele?
Your Honor, I mean, I understand officers not being here, but based upon the allegations, I don't think that would be the correct thing to move forward with, Your Honor.
Okay. Do we know why the officer's not here?
I just reached out to my investigator. Oh, he wrote me back. Apparently, this officer no longer works for the police department.
Oh. So do you have a motion, Mr. Steele?
Yes, Your Honor, at this moment, because we don't have the victim on as well. I mean, I would still try to continue to get the victim here in place of the officer, Your Honor.
That wasn't what I was hoping to hear, Mr. Steele.
I was pretty sure of that, Your Honor.
We're new in our relationship, and you're breaking my heart already. Okay, so I am inclined to grant Mr. Moore's request absent a compelling reason from the state that, and I know it's not your fault, but that you're not prepared to go forward at the given date, at the given time, in the given hour.
Yes, Your Honor. I mean, other than what, like I said, just finding out that the officer no longer works at the department, we're just not prepared. So definitely within your discretion, Your Honor, to dismiss at this time if you see fit.
Hey, I'm in the Zoom meeting now. If they doing it record or no?
Mr. Davis, we can hear you, sir.
How you doing, Judge? I apologize. I just want to make sure I'm in the right Zoom meeting.
What case are you here for?
Washington, sir.
You are right on time. I was just about to send the sheriffs out to look for you.
Well, I'm in my patrol car, so I'm here.
Okay, well, I like that response. So, all right, so I'm going to grant the motion as it relates to Mr. Hornsby. The charge, I understand your concern, Mr. Steele, given the charge. But I can't in good conscience have him sit here while we figure things out. So that's gonna be a dismissal.
Thank you, Your Honor.
And I'm gonna say because of warrant of prosecution, Mr. Steele, but I would have preferred to have written at the state's request, but I understand. Are we prepared to go forward with Ms. Washington?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Okay. And this was one Ms. Gross said Lister and Holt is going to be appointed to, or will be, or has been verbally appointed to. I don't know if I've signed the order yet.
That may be one of the ones that you just sent back. If you give me just a second, I'll check.
Okay. Yes, I sent it back. I signed
Yes, I do
it.
have it, Your Honor.
So I try to keep things as lighthearted as possible. We deal with serious issues, and it's good to laugh when you get the opportunity to laugh, but it does not mean I do not take each one of you and your cases and your causes seriously. Are we waiting on them to bring Miss Washington up? Or over?
Yes, Your Honor, because I do not see Ms. Washington.
Okay.
I apologize, Your Honor. We're getting it right now.
Okay. Miss Washington, good afternoon, ma'am. My name is Brad Gardner. This is your preliminary hearing for the Magistrate Court of Clayton County. I just want to caution you that anything that you would say here is not private or privileged, so please don't discuss or make any statements that you wouldn't want the whole world to hear, okay, ma'am?
Okay.
Okay, Mr. Steele, will you swear in Mr. Officer Davis and then begin your questioning?
Yes, sir. Thank you, Your Honor. Officer Davis, can you please raise your right hand? Do you swear to tell the whole truth?
I do.
And can you please state your full name for the record?
John Mark Davis,
And where are you employed?
Clayton County Police Department.
You can put your hand down, sir.
Oh, I'm sorry. And how long have you been employed there?
14 and a half years. I'm a sergeant now. I got promoted.
Excuse me, Sergeant.
Congratulations.
Congratulations.
Thank you.
And so you were employed there on September 30th, 2021.
I was.
And on that particular day, were you called out to 2004 Morris Drive, Riverdale, Georgia?
I was.
Is that location in Clayton County, Georgia?
It is.
Is it a residential or commercial property?
Resident.
And why were you called out to that location?
I was called out in reference to a domestic disturbance.
And when you arrived on scene, did you make contact with anyone?
I made contact with 3 parties involved. The victim himself, the Ms. Washington, as well as a witness, Mr. Byron.
And speaking of the victim, that would be Mr. Alvin.
Yes, sir. Lamario Alvin.
And what did the victim say happened?
He stated that he was in the, I guess he was coming out the restroom, or he was coming out his bedroom or something like that. And he stated that I guess Ms. Washington went inside the restroom. When she went inside the restroom, she came out. She was upset because he stated that she said that accused him of leaving feces in the toilet. And he advised her that he did not do that. And it escalated to a point of getting physical.
And to the point of getting physical, what exactly was that contact?
He stated that she had a spray container, a yellow spray container that contained some type of fluid and ended up in ammonia. He stated that she squirted at him, sprayed in his face as well as eyes, causing stinging sensation. And he also stated that she threw water at him.
And speaking of the witness, Byron, did Byron observe any of this physical contact?
He didn't observe her spraying the solution in him, but stated he observed her throwing water at him.
And so at any point, did you make contact with the defendant?
What's that, sir?
At any point, did you make contact with the defendant?
After I talked to both parties, I did make contact with her.
And did the defendant admit to spraying the defendant in the face with ammonia?
She admitted that she did it. And the reason why she said she did it because they had issues in the past that he came at her as an aggressive manner, and she felt the need that she had to do something to in case he got more aggressive toward her, that she felt the need that he might have been a threat. So she sprayed the solution at him.
Did the defendant admit to throwing water in the victim's face?
What's that, sir?
Did the defendant admit to throwing water in the victim's face?
I know I gotta look at it. I know she stated that she did spray the solution at her. I can't recall about whether or not she said she threw water at him or not.
Does the defendant or a victim live together at the time of the incident?
The victim stated that that she had been staying there about 6 months.
Okay. No further questions, Your Honor. Thank you, Sergeant Davis.
Mr. Gross?
No problem.
Yes, Your Honor. And Your Honor, I'm having some internet difficulty, so if I freeze up, if you'll give it just a second, it'll clear. Officer, you stated that they had been living together for about 6 months, but excuse me, this location is a group home, is that correct?
I believe it's a group home. Yes, ma'am.
Okay, so basically you have people who live in individual rooms, sort of like an apartment. Is that
That's
correct?
true. Yes, ma'am.
But there are some common areas, and the restroom is a common area for all the residents. Do you know if that's correct?
That's correct.
Okay, and that's what this argument started over was because our client was cleaning the restroom and had some issues with how the alleged victim, Mr. Alvin, was using the restroom or was leaving it when he came out of it. Is that correct?
I can't say whether or not she was cleaning it. I can state that she stated that I guess when she went in there, she seen a feces inside the toilet, and she accused the victim of possibly not flushing it or whatever and leaving it there.
Okay, and when she came out of the restroom, she was holding in her hand a bottle of cleaner. Is that
Cleaning solution? Yes, ma'am.
Cleaning solution, all right. And an argument ensued, at that point between the two of them. Is that what you were told?
Yes.
Okay. And according to our client, Ms. Washington, she stated there had been previous difficulties between she and Mr. Alvin in which she felt threatened. Is that
That's
right?
correct.
Okay. And based on her having felt threatened, she stated she sprayed the cleaner into the air between where she was standing and where he was standing. Is that correct?
Oh, she stated that she sprayed the solution in his direction, which it made contact with his eyes and his face.
Okay. When you say in his direction, unless the two of them were touching, if they were standing some distance apart, then she would have sprayed it into the air at Mr. Alvin. Is that correct?
I can't say whether or not she was spraying in the air. I didn't know she sprayed it toward
Okay.
the victim, which made contact with him.
Okay. And when you say it made contact with him, you did call the Clayton County Med Unit. Is that correct?
I called the Clayton County Med Unit.
Okay. And you had them come and check out his eyes.
I did.
And they did not feel the need to transport him anywhere for any treatment. Is that correct?
No, I believe that they checked him out, and I believe that he refused to be transported.
Okay. So there was not a significant enough injury to his eyes that he needed to be taken anywhere for treatment. Is that correct?
I can't say that because I'm not a medical personnel.
Okay. And you said that Mr. Alvin stated that there was water thrown on him. Did anyone explain where the water came from?
No, ma'am.
Okay. All right. I think that's all I have right now, Your Honor.
Okay, anything else, Mr. Steele?
No, Your Honor.
Okay, may this officer be excused?
Yes, Your Honor.
Sergeant Davis, sir, you can be excused. Have a good day.
All right, thank you, sir. You have a good day as well.
Okay. Any argument?
I reserve, Your Honor.
Just very briefly, Your Honor. I believe the testimony is that there was some sort of argument over the cleaning or the status of the restroom. Our client stated that she felt threatened, and that in response to feeling threatened, she sprayed the bottle in the direction of the victim, alleged victim, Mr. Alvin, and that in doing so, there's no evidence that that actually landed on his skin, that it actually landed in his eyes. The testimony is that when the EMS personnel came out and checked him, that he was not transported. He refused transport, so clearly there was not a significant injury. And based on that, and based on the fact that, you know, she told the officer that she was acting in self-defense as she felt threatened by Mr. Alvin, we would ask that you not bind this case over.
Mr. Steele?
Your Honor, based upon the testimony, based upon the allegations, it's kind of serious to spray cleaner, ammonia, any thing that could be that dangerous in the direction of, in the face of a victim, Your Honor. And that's essentially what we have here, and we are asking that you find probable cause, Your Honor.
Okay, based upon what I heard, I'm going to bind this over as a simple battery. Ms. Gross, do you want to be heard as it relates to bond?
Yes, Your Honor. Our client has been in jail. If you'll give me just a second, I'll be able to tell you exactly how long. And she is not able to make the bond that's been posted for her. As you can tell, she was living in a group home situation already, so finances are very tight. We would ask that you would consider consenting to reduce her bond to an unsecured judicial release. And that way she will be able to return back home, return back to her work and to her regular life while she waits for this case to be handled in court. And just 1 second, I'll tell you how long. She's been in jail since September the 30th, Your Honor, so roughly 45 days.
Mr. Steele, do you have a response?
Yes, Your Honor, I will be objecting based upon the seriousness of the allegation.
There is, so Ms. Gross asked a question that was in my mind that I was going to ask as to whether there was any kind of medical treatment that the alleged victim received, and based upon the testimony that the police officer, Sergeant Davis, called out EMS, they came and they didn't transport him. It changes the scenario in my mind. So I'm gonna reduce the bond to $1,000, given the fact that she's been in jail since September 30th. And based upon the testimony that I heard, it reduces the seriousness of this case in my mind. So Ms. Gross, if you will draw up a bond order for this, I'll sign it. And the case is going to be bound over as a simple battery. All right, what's the next case?
Your Honor, I see a Kia's iPhone, and I'm not sure who that is.
Kia's iPhone, would you turn your camera on and identify yourself, please? Kia's iPhone, Keyya apostrophe S.
I'm sorry. Am I on camera? Because I'm not prepared to be viewed.
Okay. Let's identify yourself.
Okay, I'm just here as I'm viewing as a support for one of the cases that's coming up.
Are you going to be testifying?
No, sir.
Okay, so this is being broadcast on YouTube. That's where you go to view.
Okay.
Okay, I've had to mute you a couple times. So please, I'm going to remove you and you can go to YouTube and you can provide support there.
All right, thank you.
Okay, thank you.
Okay, bye-bye. All right.
Bye.
And Your Honor, at this time, we are not moving forward with Perry. We've had this continue twice for the officer.
You said Perry with the P?
Yes, Your Honor.
Okay.
So we've had it continue twice. The officer has not shown, and we have not been able, we've been in contact with the victim, but the victim is not here, so we are not moving forward at this present time, Your Honor.
See, Mr. Steele, now you're coming back to me.
Because, Your Honor, you know, we tried our due diligence, and so this is where we are now.
Thank you, sir. All right, what's the next case?
I think that's it. It is bond modifications.
Okay, so for the jail, Mr. Perry can go back.
Blackman. Did we finish up with Blackman?
I thought it was going to be a UJR and a waiver.
Okay.
We're all set on Blackman as far as I know.
Yes, so Blackman can go back also.
Yes, sir. Perry and Blackman.
Yes, ma'am. Okay, so with let's see. Let me see. Is it? Oh, Miss Gross. I looked up with Dehus.
Jesus.
There you go. I used to be able to say that. So I'm not going to grant a UJR bond because I'd looked at the criminal history and I just don't feel comfortable doing that. But I am willing to entertain other, let me see. my notes indicate, which they're incomplete, but it says UJR taking meds, that he's currently now taking meds as prescribed.
That's correct, Your Honor. She is, she's.
Or
in
she,
the-
I'm sorry.
It's okay. Because she's in the jail, she's taking the medication, excuse me, that the jail will give her. It is not her complete regimen of medication, but it is her basic medication. She is completely competent, fluent, had no trouble discussing the case with her. So she is perfectly safe to be released at this point.
And just to, let me see, jog my memory. What was your request? Because I don't see as though that there was a hearing, but that was your request was for
That's
her
correct.
to have a UJR bond.
That's correct, Your Honor. And I believe, if I recall correctly, the officer wasn't here is the reason that we weren't having a hearing.
Okay.
But okay, that's Mr. Steele says that's correct. She had, the reason she was off her medication is she had been in the hospital. She was released from the hospital, and instead of going back home, she went to stay with someone to help her, on her release from the hospital. The difficulty there was it meant she didn't have her medicine, which was back at home.
Right.
And so that's the reason she was off the medication leading to the incident that occurred.
And the state's announcement on that was that you're leaving it in my hands?
Yes, Your Honor.
Okay. All right. Let's see if we can fashion a remedy in this case. I'm trying to pull her thing up to see what. Jesus. She's unable to make the $1,500 bond that was set.
That's correct, Your Honor.
So let me ask you this question. Do you know of her ability to make any bond?
Your Honor, I did not specifically ask her that question. I'd be happy if you let me know what further information you need. I'll be happy to go back out into a breakout room and spend a minute or two with her and get whatever information you need.
Well, so given the charge and the length of time that she's spent in custody, while I'm not willing to grant a UJR bond, I am willing to grant a very, very reasonable bond. And so I 12 years ago, I know $1,000 was the cutoff for what a bonding company would come in on. So I'm willing to reduce the bond to an amount that she can pay. But I don't want to just say, okay, oh, it's $500 bond. Of course, she can pay a $500 bond and she has $200.
Right.
So I'll put you in a breakout room with her so you can have that discussion. And then we'll try to, in the meantime, with Mr. Moore and Mr. Steele, Mr. Kim.
Yes, Your Honor.
I feel like you're ignoring me. I haven't had a chance to speak to you all day.
Yes, Your Honor. I believe you guys are trying to get through the prelim hearings first.
Okay.
I'll be handling all the bond modification or majority of it.
Okay. All right. Okay. So I'm gonna, would you please set up for Miss Amy Marie De Jesus at the jail so that Miss Gross can speak to her, and I'll.
Yes, sir.
Okay, so both of you are already in the breakout room, so you should be able to click on the link.
Right. Thank you, Your Honor.
Okay, so other than the bond modifications, do you have anything else, Mr. Moore, that we have not heard?
Your Honor, I think the only things that are left are bond modifications. I think everyone else was either, we've already handled all the hearings, and anybody that we hadn't had a hearing on was a waiver, as far as I know.
Okay.
That includes Lee and Whipple.
Okay.
Or, sorry, Your Honor, just let me clarify on Mr. Whipple. My understanding is, I'm very familiar with Mr. Whipple. He's our client. I've met with him numerous times. I know he has a significant mental health issue that causes him to vacillate between being competent and incompetent. And so at this point, I think we just be asking the court to administratively bind his case over so that we can take the appropriate measures once we get him into state court.
Okay. And so, just so I'm clear, when you say administratively bind over, that's for me to just fill out the paperwork. It's not something that you send over to me?
Correct, sir. In the past, what I think most judges would do, they've referred to it as judicial bind over or administrative bind over, simply when somebody's essentially not able to participate or have
Right.
any input or in any way deal with their preliminary hearing. We just kind of let the court know our experience with them. And for the most part, I think the judges exercise their discretion just to go ahead and send it on over on that
Okay.
basis.
I have that on my notes that you announced that he was OTB.
I had been informed of that, but I do see where he's currently in custody.
Okay.
So, and I don't think that the jail had brought him up because
Okay.
of that.
No, that's fine. And you said Mr. Lee was the other person?
Yes, Your Honor, provided that the court is going to appoint us on that. He was one that was coming down from the public defender's office. And it's currently in, there's a misdemeanor. I think the state may or may not be looking at it as a felony, but for our purposes here today will be appropriate. Well, I've already discussed the issue with Mr. Lee for us to file a waiver on that.
Okay. And that's what my notes indicate. If you send me over an appointment order, I'll sign it.
Yes, sir.
I just sent back the stuff you sent over earlier.
I received those. Thank you.
Okay.
Yeah, and as we go, I'll start getting them into you via email.
Okay.
For Lee and a few of the others.
Okay. All right. So Mr. Kim, Mr. Steele, let's get started on Mr. Kim's matters, and just tell me the name and we'll start from first person. Keep it going.
Do you have any preference, Mr. Steele?
I do not.
Okay, I guess we can just go alphabetically. Would it be possible to do Mr. Jonathan Flippin?
Okay, Mr. Flippin. And for each of these, you're advocating to have the bond reduced, correct?
If possible, we would like to request from the court an unsecured judicial release for all the clients.
Okay. Well, we're going to take it on a case-by-case basis.
Yes, sir.
Do you need to have Mr. Flippin here?
No, Your Honor.
Okay. I'm just pulling up their his paperwork. Sorry, there
No
bunch of
problem.
different attachments, and I'm just trying to get to it. I don't see his information. Goes from D to G. Okay, Mr. Kim, go ahead, make your presentation, and if I believe I need, and I'll listen to Mr. Steele, and if I believe I need to go look at that more, I will.
Yes, Your Honor. Thank you. I would first like to introduce the procedural posture of Mr. Flippin's case. Mr. Flippin was arrested for criminal trespass and battery on or about July 31st, 2021. He waived his prelim on August 1. However, his case has had no activity and has yet to been bound over. He's been in custody for almost about approximately 4 months. Additionally, I did want to shed some light in regards to his personal life so the court can take that into consideration. Mr. Flippin, he is not married, but he is a co-parent. He does have 2 children, the age of 6 and 9. The children live with the mother in Milwaukee. However, he is legitimized as the father and does pay child support. In regards to his working, he was previously working at Amazon prior to his arrest. He has spoken with the manager, who has informed him that they are willing to take him back. He does work full-time and often works overtime in order to help sustain with the support of child support. From my understanding as well is that I anticipate that the state will probably introduce the arrest history, but from discussing with the client, he's indicated that he did have a prior arrest in 2019, but the warrant was denied in magistrate court. He's indicated that there was no other arrests in Georgia that he's aware of. He did mention that there was a warrant back in 2016, but it was for driving without a license. He's claimed that he immediately turned himself in after discovering that. So I believe that shows an indication that he's not a flight risk. And for his housing, he does have a place to go. He's stated that he will be residing at his brother's house if the court will allow for his release.
Okay, Mr. Steele.
Based upon what Mr. Kim said, it is correct. There was one previous that did not seem it went forward. The second Georgia case is the one that's at hand. There seems to be some history out of Wisconsin. Did you want me to read it to you, Your Honor?
How many convictions does he have?
Out of Wisconsin, I'm seeing 1, 2, 2.
Okay.
The first being operating while under influence, and the second being operating while revoked, which I'm assuming is license revoked. The thing that worries me the most about this case, Your Honor, is of course the fight, but the defendant trying to reach for a firearm, based upon the allegations, Your Honor, during that altercation. Of course, I'm leaving it within the discretion of the court. The state fully understands the defendant has been in jail since July 31st, and that's a hefty time. So I'm leaving that within your discretion, Your Honor.
Okay.
Oh, and our victim's advocate did speak to the victim, and he stated that he was not afraid of the defendant. Just wanted to make the court aware of that.
Okay. Let me see. Let me see. I'm just looking to see. Nope, he didn't appear before me. Seems like he had his first appearance on August 1st. Yeah, August 1st. So I don't have any information on him in the packet of information that I received. Let's see. What was his original bond?
From my understanding, Your Honor, I believe it was 5,000 for the battery and for the criminal trespass, 3,000.
It sounds like what I would have said. Five, 3, 8. So I'll reduce it to 1,000 on the battery. And actually, let me do this. I'll do 500 on the battery and 500 on the criminal trespass for a total bond of $1,000.
Your Honor.
And just if you send me the bond order, I'll sign it.
Yes, Your Honor.
Okay, what's the next case?
Your Honor, if I might, I just had a question about for the bond motions, and thank you very much for your ruling. In addition to that, is it possible that if these cases, because I believe most of them should have been bound over maybe like several months ago, if the court could issue another order binding it over, or somehow, just in case he can't make that bond, go ahead and move the case along.
Yes.
But the majority of I think all of these actually are kind of in that posture where they've just kind of been sitting for a long time and the cases haven't been bound over. And that's why the bond motions are mostly before you. I just want to give a little context to what was happening there.
Thank you. And in my mind, that is what I was doing. So let's just make it explicit that the bond is we had the hearing, or bond modification hearing, bond was reduced, case being bound over to state court.
Thank you very much, Your Honor. Appreciate it.
No problem. Thank you for bringing that to my attention.
Sure.
And Your Honor, if I may give an announcement on Ms. De Jesus.
Yes, ma'am.
I have spoken with her. The difficulty that she's having, she hasn't been able to get in touch with her father, and bonding companies won't take the phone calls from the jail. So even though she has enough money in her property at the jail to post the bond, if she could do it through a bonding company, she can't seem to get in touch with anyone. I've attempted to call her father. He is out of the country, said he will be back later this afternoon. And so I might be able to reach him. I don't know if he would be willing to bond her out or not, but at least I do have that contact information now.
What amount was she able to post?
She said that she has, I believe she had $300 with her.
Okay.
originally, and I think now they've added some money to her. She's on Social Security disability, and her mother is the payee on that. And I believe her mother has added some money to her card. She believes at this time she has 500 on her card.
Okay.
But that is literally the money that she needs to have to eat for the next month.
So if you draw up a bond order for $100, I'll sign it.
Okay.
Deputy Requena, are you still over there?
No, sir, I'm here now, sir. Stephanie's here.
Okay. Would you do me a favor?
Yes, sir.
There's a inmate, Amy Marie De Jesus.
Yes, sir.
We're going to make arrangements for her to be able to post a bond. My understanding is that she has money in her property that she can post the bond on. Would you either ask someone to allow her to have access to that? The bond is going to be $100.
Yes, sir. I will pass it on to the correction department supervisor.
Okay, and and let them know that if there's an issue, Chief Hardnett can call me, and I can explain the situation to her. Because we're just trying to help this person get out of jail, and this seems to be the quickest route for that to take place.
I'll take care of it, sir. I'll take care of it.
Thank you so much.
Yes, sir.
Okay, what's the next matter we have?
Yes, Your Honor. Could we address Mr. William Grimes?
Grimes, okay.
I think didn't he refuse?
Oh, sorry. Yeah, he ended up not showing up today, I believe.
I mean, I guess we can still address bond. I just remember I think he said he wasn't going to be in the jail. Anyway, just wanted to make sure I was thinking about it correctly.
I forgot.
He politely declined.
So if I may, Your Honor, so I did want to introduce the procedural posture of this case as well. Mr. Grimes was arrested for disorderly conduct on or about August 23rd, 2021. He waived his preliminary hearing on August 24th, but his case has not been bounded over and there hasn't been any activity. He's been in custody for a little less than 3 months. I did want to present to the court some factors in order for them to make a decision. I did want to make aware to the court that Mr. Grimes does have schizophrenia. However, when we did visit him, he was able to express himself coherently. In regards to his living situation, if he was to be released, he's indicated that he has a place to go. His stepfather, Mr. Randall Elder, at 5836 Trammell Road, Morrow. He has consistently lived in Atlanta for majority or almost entirety of his life. He lives off disability. However, he is planning to work at Little Giant Food Store part-time. He does have a brother who does currently reside in Clayton County. He also has an aunt who lives in Atlanta, Georgia. Speaking with the client, he's indicated that from his knowledge that he has one felony shoplifting charge from 1998, but nothing else that he could remember. In regards to his case, he was previously homeless. The reason why he obtained a charge was, I believe, he was yelling at a Clayton County Fire Service for food assistance. So that may be the reason why the officer ended up arresting him, Mr. Grimes, for the disorderly conduct.
Okay, what's the state's position, Mr. Steele?
Your Honor, this defendant has 28 cycles out of Georgia, 17 convictions, 10 cycles out of South Carolina, 7 convictions. The case before us, the disorderly, based upon allegations, it appears that this was an ongoing problem, but apparently this is the first time that they actually called the police regarding the defendant. We are definitely leaving this within the discretion of the court. The defendant has been in jail since August 23rd of this year. So we're going to hold no position, Your Honor. We'll leave it within the discretion of the court.
Okay.